We are going to continue our morning session. Mr. Horta, for the respondent.
Thank you, Mr. Chairman. I would like to start off also by thanking the members of the tribunal, the secretary of the tribunal, the ICSID staff, and all of the folks who have worked to put this hearing together. I'd like to thank opposing counsel. We have gone down a long road in this case. It started back in 2007 when claimant filed their notice of intent to arbitrate and eventually their request for arbitration. To put us in context, you might recall that in the opening I started off with a series of points about what this case is really about, and here we're boiling it down even to its more basic form. In 1997, claimant, through their local enterprise, participated in a bid to modernize and restore the Guatemalan railway. I think the evidence demonstrates that they didn't have sufficient capital, and their projections in terms of demand, in terms of funding sources, were optimistic and turned out to be completely off the mark. So things didn't work out between the parties. Now, as you're going to hear in a second, none of the actions that have been signaled by claimant in relation to conduct by Guatemala constitute actions that would substantiate any of the treaty claims that they are asserting in this case. There simply have been no treaty violations proven. We think that the hard evidence proves that, and we hope that throughout the course of this case and the 8 or 9 days of hearings that we have had, that the evidence has borne that out for the tribunal. Now, you've heard from testimony from various witnesses that there is a local proceeding pending in relation to the declaration of lesividad. And you've also heard that there are local arbitrations pending regarding many of the issues that have been complained about here, and the tribunal ruled early on in this case that those issues pending in the local arbitrations were outside the bounds of its jurisdiction in this case, given the terms of CAFTA. At the end of the day, it's our contention that the appropriate conclusion for this tribunal to reach is that there has been no violation by Guatemala of its undertakings with respect to CAFTA, and the issues between the parties can and should be resolved locally. Now, when we started this hearing, we mentioned that there were basically two issues that we believed that this tribunal needed to decide. The first is whether Guatemala violated its CAFTA undertakings when it applied the Lesivo law, which the evidence shows has been part of Guatemalan law for over 100 years, to declare the usufruct equipment contract Lesivo. In the face of the decision that President Berger made, and given all of the circumstances associated with that decision when it was taken. That's what we believe this tribunal is being asked to answer. Because after all, when claimant framed their case, they claimed it based on the issuance of the Lucido Declaration and the consequences thereof. That's how they framed their case to this tribunal. Looked at in context, we also contend that what is in essence really happening here is that the tribunal is being asked to shift to Guatemala the responsibility for claimants' failed and risky business venture. And we say that because we believe the evidence shows that claimants, in fact, did enter into a very risky business venture, and that business venture failed long before the Lucido Declaration was issued. And we further believe that the evidence demonstrates that when CAFTA went into effect and the Lucido Declaration was issued, claimant immediately seized upon that as its exit strategy from a failed venture in Guatemala. Now, I'd like to start where I think the tribunal will be focusing a good portion of its time when it deliberates in this case, and that is the Lucido Declaration and whether the actions taken by Guatemala in relation to the issuance of the Lucido Declaration violate Guatemala's undertakings under CAFTA. And I want to remind the tribunal it is our contention that this tribunal need not decide whether the Lucido Declaration was properly issued under Guatemalan law. That issue is before the administrative court in Guatemala. Now, looking at the actions that were taken by the government, we know that between April 2004 and June 2005, the parties undertook negotiations in relation to the possible amendment or undertaking of a new equipment contract, because very shortly after Dr. Gramajo took over as the overseer of FEGUA, he notified claimant through FEG that the contract suffered, the equipment contract, the one at issue here, suffered from legal defects. And we know that because there's been testimony to that effect from Dr. Gramajo. There have been draft agreements shared with the tribunal. They're part of evidence, R50, R51. And there are email exchanges between the parties in relation to those draft agreements. And I think both sides admit that there were negotiations going on, but that those negotiations ultimately did not prosper. Now,
whether you'd moved on. You say the tribunal need not decide whether the contract is lesivo, but you accept that we could decide that. Is that right?
well, it's our contention that that issue, in other words, whether it's actually lesivo under Guatemalan law, is not really relevant to the undertakings of determining whether Guatemala violated its CAFTA obligations.
I mean, certainly, as you say, it would be possible to decide the case without deciding it. But if we were to decide that the President was entitled as a matter of Guatemalan law to declare the contract lesivo, that would surely have considerable relevance to a fair and equitable treatment claim.
I think that's correct. I think that's correct. The only point we're making, and I think this goes to the first aspect of your observation, Professor Crawford, is that you need not get there, in the sense that the conduct that is at issue can, we believe, demonstrate that Guatemala did not violate fair and equitable treatment standard or any other of the claims that are at issue here. Yes, sir. Now, in relation to the timeline, in or around June 2005, actually dating back even a little bit earlier into April 2005, we know that at that point negotiations between the parties had not prospered, and both sides, in essence, began considering what legal options they had in relation to some of the problems that they had between each other. We know, for example, that Ferrovias began planning their local arbitrations. We've seen email exchanges. They were part of the record in this case. Witnesses were questioned about them, where Ferrovias' witnesses said that they were launching their attack against FEGUA. This is a direct statement made by Mr. Sen in one of his emails in April of 2005. And that attack was the local arbitrations that they were filing in relation to the issue of squatters and trust fund payments that this tribunal is well aware of. Now, Dr. Gramajo has testified, both through his oral testimony before you and through his witness declarations that in April 2005, recognizing that the parties had reached an impasse in relation to trying to resolve the legal defects associated with Contract 143 and 158, he began making inquiries to first the legal department within the Ministry of Communications. That's the ministry to whom the railway agency responds, and eventually consulting with outside counsel, the Attorney General of Guatemala, and all of that led him to receive a number of very consistent opinions from these legal advisors, including from the highest legal authority for the state in Guatemala, that the contract at issue had a number of important legal infirmities. And, time and time again, claimant likes to call them legal technicalities, but I think if we're being fair, these are much more than legal technicalities. Whether or not the contract should have been put to a public bid is not a technicality. Public contracting laws are very important for governments, especially developing nations, and upholding those contracting laws is not a matter of just a mere technicality.
Wasn't that the government's responsibility to do? I mean, if this was something that was important, why didn't they do it?
Well, Secretary Eisenstadt, in relation to the execution of Contract 143 and 158, we don't know why the overseer of FEGWA at the time did not celebrate a public bid. We don't know why he chose, and this is of record, you have the declaration of Mr. Mario Cifuentes, who was his legal advisor at the time within FEGWA. We don't know why he chose to ignore his legal advisor's advice and sign an agreement that did not comport with Guatemalan law. Now, I want to be fair. His legal advisor at the time did not say to him a public bid was necessary. He did say executive approval was necessary. And I think when you examine the documentation, you'll see in the record that the initial reaction to this contract, both from the legal advisor to Mr. Sarceño before he entered into the contract, and when the legal team that was advising Dr. Gramajo after he entered in as the overseer, when they analyzed the contract, neither of them initially recognized that a public bid was necessary. Rather, they both took issue with the fact that in the original bidding terms for Contract 41, there was a necessity for there to be a public bid. It was a requirement of the bidding terms, and we believe the contracting law requires it, because when you're giving state assets to a third party for their use, the contracting law requires that a bid take place. Now, in relation to the issue of incorporating those bidding terms into Contract 143 and 158, both the advisor for Mr. Sarceño and the legal team for Dr. Gramajo immediately recognized that it was a violation of Guatemalan law to incorporate those bidding terms into the contract when those bidding terms say that a bid is required, and when those bidding terms say that executive approval is required, and then to unilaterally write into the contract write out in the contract the requirement for executive approval. That's the main defect that was immediately spotted by both of those legal advisors. Once Dr. Gramajo elevates this to outside counsel and the Attorney General's office, that's when he is first informed about the public bidding requirement from outside legal advisors, the fact that had not happened. So earlier on, that the record will establish he wasn't told that.
But didn't Ferrovias have a right to rely on the signature of an overseer to the contracts under which it was operating, and the fact that pursuant to that, the government was accepting, or FEGWA was accepting, canon fees? I mean, isn't there a reliance issue here that needs to be addressed?
And I'm going to address that later in the slides, but just to directly address your question, Secretary Eisenstadt, the answer is that we believe reliance under international law, public international law, has to be reasonable. And one cannot rely upon their own misconduct in asserting a claim under CAFTA. And here, we believe the evidence demonstrates amply that at the time that Ferrovias was executing or entering into the contract 143 and 158, they knew full well that executive approval was required. Why did they know that? Because the bidding terms for contract 141 required it. Their letters to overseers throughout the years acknowledged that contract 41 never went into effect because they didn't have that executive approval. And yet, notwithstanding that they incorporate the very same bidding terms which require executive approval into contract 143, they say in the contract that that executive approval is not going to be required. Now, admittedly, Overseer Sarceño overstepped his bounds. He should not have done that, and we've heard that here. But the point, in response to your question, is that Ferrovias understood that was not in compliance with Guatemalan law, and they cannot reasonably rely upon the acquiescence by the FEGUA overseer at that time when they themselves knew that that was not in compliance with Guatemalan law. That's our contention. And in relation to the issue of the acceptance of payments, you heard from Dr. Gramajo that from his perspective, the payments were being accepted by FEGUA pursuant to the letter authorizations. Again, even if you were to accept that that FEGUA was, after the execution of Contract 143 and 158, accepting payments pursuant to that contract, which FEGUA itself had told Ferrovias was not in compliance with the law, Ferrovias, FEG, cannot be excused based on that because, again, they themselves knew that they were making payments, even if it's pursuant to the contract, pursuant to a contract that they themselves knew was not in compliance with Guatemalan law at the time they entered into it. And we've cited the principle. I mean, in our system, the doctrine of unclean hands. There's a similar principle in public international law, and they can't benefit from that misconduct, if you want to say it that way, or from their knowing that they were doing something that was not in compliance with Guatemalan law, and they cannot invoke that here to excuse their conduct in entering into an agreement that they knew was not in compliance with the law. Now, going back to the issue of the reasonableness of the decision made by President Berger to issue the declaration, we know that in January of 2006, President Berger receives a letter from Dr. Gramajo in which Dr. Gramajo cites a number of grounds as to why he understood the contract was lesivo to the interests of the state. And he asks the President to consider making that declaration. Now, the evidence shows the President didn't seize upon this letter and immediately sign a declaration, immediately instruct anyone to sign a declaration, or instruct anyone to do anything other than have his legal team look into the question that was posed by Dr. Gramajo. And his legal team did that. Between January and April of 2006, they asked the Ministry of Public Finance, which we heard is the ministry dealing with public contracting. They had three separate advisors that looked into, three separate legal advisors within that ministry that looked into the question of whether the contracts were lesivo. And with what we believe is a good amount of consistency between the other opinions, notwithstanding that they were conducted independently. And the record evidence is that these determinations by these various different officials were conducted independently, and that's unrebutted in this case, reached the opinion that Contract 143 and 158 was lesivo to the interests of the state. Those opinions get transmitted back to the legal advisors for President Berger. They conduct their own independent analysis, and at the end of the day, what we have are 9 separate independent legal opinions that are put before President Berger, telling him that these contracts suffer from important, fundamental legal defects under Guatemalan law, and telling him that he should issue the Lucido Declaration. Now, again, there's no dispute that these opinions were all based on technical legal analyses by these different public officials. We also know, and this is undisputed, that President Berger was counseled that in light of this contract containing these illegalities, that not only should he declare the contract lesivo, but that if he failed to do so, he would incur in personal liability himself. Now, there's been much questioning from the experts as to whether, in fact, President Berger under Guatemalan law would be subject to personal liability. We believe the answer is yes. We understand you've heard 2 different opinions from Guatemalan law experts on that, and we've cited you to the law. We would remit you to the Articles 153 through 155 of the Guatemalan Constitution, and the other sources of law cited by Professor Aguilar, Mr. Aguilar, and but I think the real inquiry here, again, is, was it reasonable for the President to make the assumption that he was going to be subject to personal liability when he's being told that by the equivalent of the White House counsel, the equivalent of the chief lawyer in the office of the presidency? And we believe the answer to that is yes. And so when you put all of those things together, and when you take into account that none of these other factors, okay, that have been cited here by claimant as the real reason that the Lucido Declaration, we believe, were really at issue, that none of those were at issue, we believe that the issuance of the Lucido Declaration was reasonable, and therefore we believe that there are no violations of CAFTA.
I think that seems to be replete in the record, including Mr. Maricchino's statement today, but it just comes in time and time again, was that there was a comprehensive negotiation to deal with a whole variety of issues related to the railroad operation, and that this particular set of defects, I think we shouldn't characterize or mischaracterize them as technical, because that already evidences some indication, but the defects themselves were not really central parts of the negotiation, and had they focused on trying to correct those 2 defects, the bidding and the presidential thing, you might have had a potentially different outcome, but instead they were focused on the whole broad range of decisions, the South Coast, and a whole variety of other issues, and that, I thought, was also what Mr. Maricchino said this very day, and that correcting the legal defects would not have achieved, for example, he said, the goal of the high-level commission, which was to get the railroad back into operation. Could you respond to that concern?
Sure. Secretary Eisenstadt, I think, again, here we should look at what the evidence shows. Ask yourself, why is it that the parties are, in the context of the discussions that were taking place from the high-level commission, and in the context of the settlement discussions that were taking place just before the Lucido Declaration, why are these other issues part of the equation? And I think that the evidence will demonstrate that the reason they were part of the calculus by the parties was, first of all, because claimant, through Mr. Posner, through their local partners, through Cementos Progresos, they requested a meeting with the President of Guatemala in March of 2006. This is unrefuted. And the purpose of that meeting was to put before the table all of the issues that were plaguing the parties' relationship so that those issues could be dealt with and resolved by the parties. Now, I think that speaks volumes as to why it was that those issues were being discussed. We can't blame Guatemala under CAFTA for demonstrating their good faith in opening the office of the president to Mr. Posner, hearing him out, letting him make a presentation, and then the president making an instruction, let's form a high-level commission to decide to try to resolve these issues that are at issue between the parties. And certainly it makes sense that the president would be focusing on having a functioning railway, and it makes sense that his top legal advisors would see that as the ultimate end game. But you also heard very clearly from Mr. Eichenhead, from Mr. Marroquin, who testified today, from Dr. Gramajo, from Astrid Sosel, who's one of the witnesses who you didn't hear from at the hearing because they chose not to cross-examine her, but in her declaration she also supports this, from Mr. Fuentes. You heard that first of all, that the government was negotiating in good faith. You also heard directly from Mr. Eichenhead and Mr. Marroquin that there was no instruction, no order given, you must resolve all of these issues or else we proceed with Lucido. Rather, the evidence is that they were all being discussed in tandem, again, because claimant made the request that all of these issues be discussed, or that the issues plaguing the parties be discussed, and they made that request directly from the president, and he responded to it. But there was nothing impeding the parties from reaching a resolution just as to the issues of contracts 143 and 158. And the other thing, and I think this is very important in relation to the question that you've posed, is that when actual offers to sit down and negotiate and negotiate the issue of contract 143 and 158 were put before FVG, what we know is they weren't able to reach agreement in the April 2004-2005 timeframe, when that was the only issue that was being discussed, that contract. And we further know that when the claimants are confronted with a request to negotiate that issue, if you look at C-44, and I ask you to look at that document carefully, that is the settlement proposal that was put before Mr. Sen on 24 August 2006, the day before the Lucido Declaration was published. The evidence, I think, is unrebutted that while that agreement dealt with a number of issues, there's nothing in that agreement that said you have to settle all of them or we won't settle any one of them. And the other thing is that when you look on the face of the agreement as to each and every point, including the issue of contract 143 and 158, what the government was offering was to sit and negotiate a way out of the problems. There are no demands made in that document. Every one of the subpoints in the document say points to be discussed or negotiated. And that evidences that the government was willing to sit down and negotiate those points. And there's nothing in the document that says you have to negotiate them all or you will not be able to negotiate away the issues with respect to the Lucido Declaration.
Just enlighten me on one last point. Did we not hear that, in a sense from both experts, that there was virtually no way to remedy the defects, particularly with respect to the presidential approval? Once you identified it, it couldn't be remedied. Is that what the record shows, or?
I don't believe so, but if I could just make one minor point closing out on the prior question, which is in relation to that proposal, C-44, that was put forth to Mr. Sen, the evidence is unrebutted that he didn't really study it, he made no counter proposals, and he said he had no authority to negotiate any of the points in there on the day before Lucido was published. And that even after Lucido, R37 proves this point, even after Lucido, when confronted with the issue of the equipment contract, Mr. Sen said to the government officials, that issue is of secondary priority because the main point here, which is trying to see if there's a way to rehabilitate the Phase 2 is a standard gauge railway in which they wouldn't be able to use the rail equipment. In response to your other question, Secretary Eisenstadt, the testimony from Dr. Aguilar is that there was a way to settle, that the government could settle. What he said was you couldn't cure Contract 143 itself because that suffered from illegalities, but you could enter into a settlement whereby you entered into a separate new equipment contract, which is what was being proposed in C-44 and in the negotiations that are exhibited in R-36 and R-37. So you could reach a settlement, and that would involve potentially a new public bid and a new equipment contract that didn't suffer from legal defects. Now, let's look at the issues of the supposed motivations for the issuance of the Lucido Declaration as contended by RDC in this case. First of all, they've said from the beginning of this case, and they continue to maintain it today, that the government was looking to benefit Mr. Ramon Campoyo, and that was the real motivation in issuing the Lucido Declaration. With all respect, we believe the evidence on this is clear, and that is there is absolutely no evidence to support this allegation. None. You heard directly from Mr. Campoyo. He said he had no interest in the railway, never expressed an interest in the railway, never made any threats. To the extent Mr. Pinto said anything that could have been perceived by the other side as threats, he never authorized him to do that. And we know that as of April 15, 2005, a letter was sent directly to claimant by Mr. Or to FVG, I should say, by Mr. Campoyo saying he had no interest in the railway project. There's no evidence of any communications between the government and Mr. Campoyo or anyone on his behalf or Mr. Campoyo or anyone on his behalf with the government in relation to the allegation that he wanted to take the railway usufruct. And last of all, we know as we sit here today, Mr. Campoyo has no rights in the usufruct at all. On the issue of 50 million, and we're going to get to this in a little bit more detail. Again, this is based on a number of things that are really just press reports and nothing more. And lastly, on the issue of the use of the Lucido Declaration to force claimants to renegotiate, I believe I just sort of dealt with that in response to questions for Secretary Eisenstadt. And again, we'll deal with it in a little bit more detail. Claimants, again, in order to make their CAFTA claim, attempt to assert in this case that their investment was profitable. The evidence shows just the opposite, and that Guatemala took away their entire investment. And again, I think the evidence shows just the opposite. In assessing the case, I think it's important that you assess the quality of the evidence that has been presented to you in this case by claimant. Most of it is hearsay evidence, what somebody believes they heard from somebody else or from somebody else. And all of the hearsay evidence is in essence being purported by claimants' representatives or their lawyers. Huge inferential leaps. We hear words like sugar and private investor, and you're being asked to interpret that to mean Mr. Ramon Campoyo. You're being asked to conclude that it's clear that that means Ramon Campoyo. We submit that's not the case. And most of their evidence comes from newspaper clippings. Now, claimant has talked about their success and how that should evidence what they would have done here if they would have been allowed to carry out their investment. And Mr. Foster, in his opening and again today, talked about a number of other operations that RDC had and said, you should assume that the success, to the extent there was success in these other rail ventures, was going to be replicated here. But what was left out, and this is in document R322, is that Mr. Duggan has admitted that, as a matter of fact, they had never, ever implemented a project like this before. They had never, ever tried to revive an abandoned railway. Again, don't take our words for it. It's Mr. Duggan telling you this, R322. On the issue of Campoyo, again, what I'd like to stress here, and this is, I believe, important. I think I've already said what the lack of evidence is, but I would like to remit you to the direct evidence, because you heard Mr. Foster say in response to a question from Professor Crawford that the question is whether you want to credit the evidence that they have put forward and whether you want to credit the inferential or circumstantial leaps that they would like for you to make based on that evidence. And I submit to you that if you look at the documents that we have put before you, and these are mostly all documents that they have submitted in this case, communications between Mr. Pinto and Mr. Posner or Mr. Sen, look at them in chronological order. We've put them for you here in chronological order. And what you're going to see when you study them, one by one, in chronological order, is that Mr. Pinto wasn't making any threats to take their railway. Mr. Pinto, even if you assume he was acting on behalf of Mr. Campoyo, which we say to you the evidence does not allow you to make that, that leap, even if you make that assumption, you will see that what in essence was going on is that Mr. Pinto was inquiring as to whether there would be rail service provided by FVG to the southern coast, and he was asking for quotes for sugar transport to see whether that might be viable for whether that might be viable. And again, when you look at the evidence, read the emails that they've provided in context, you're going to see that Mr. Posner himself responds to an email from Mr. Pinto on 3 August 2006, just before the Lucido Declaration, and he tells Mr. Pinto that he's anticipating positive results for everyone in relation to the possible rail transport to the south. Positive results for everyone. The other communications, again, demonstrate a request about the possibility of FVG providing transport services to the south. Not Mr. Campoyo wanting to take the railway, not any insistence on the Desarrollo's G proposal. And I think it's important that you look at this and judge the quality of the evidence that's being put before you. The Desarrollo's G proposal itself, which has been talked about in this case, take a look at that proposal, and take a look at C-44, which is the settlement proposal. Those are two of the main documents that they ask you to look at when they say there have been threat allegations. The Desarrollo's G proposal is merely that, a proposal, and nothing more. Again, Mr. Campoyo says he had nothing to do with it, but even if you were to believe he had something to do with it, it is a proposal and nothing more. And the evidence shows that Mr. Pinto asked for a counter-proposal to which FVG decided not to provide. You heard they didn't provide one. Mr. Sen told you that. So there is simply nothing to their allegations about Mr. Campoyo. It's a complete non-event in this case, but I will tell you it is their featured claim of conspiracy and of discriminatory intent in relation to the Lucido Declaration, and it completely falls on its face when you look at the evidence. Now, there are other indicia of the unreliability of the evidence that is before you. You heard Mr. Mario Fuentes testify, and that's a witness that the claimant proffered in this case, that he never told claimants about any supposed plot by Juan Esteban Berger to be taking or to be manufacturing or drumming up illegalities to take away the railroad. Now, why is that important? Because Mr. Sen, Mr. Duggan, and I believe Mr. Posner tell you that the reason they believe this is because they heard it from Mr. Fuentes, from Mr. Melville, and Mr. Montano. Well, the problem that they have is that Mr. Fuentes denied having ever made such a statement to them, ever. And that's on the record, and you have the cites here. Mr. Melville and Montano submitted witness declarations, and they also deny having any ability to confirm what they call speculation by claimant. And Juan Esteban Berger told you no such thing ever happened. So that is important when you are analyzing the rest of the evidence that they've put before you. So in conclusion, on the issue of Mr. Campoyo, there's really, we submit it's a non-issue in this case. There is no evidence to support it. On the issue of the $50 million threat, okay, this is another issue that's been put before you, and they claim President Berger demanded $50 million or else he would proceed with the Lucido Declaration. Yeah, so he demanded $50 million or else he would proceed with the Lucido Declaration in relation to the railway equipment. And the $50 million was demanded, as they say, for purposes of investment in the railroad. What you see is that they're citing to nothing more than newspaper clips. And newspaper clips that were issued post-Lucido, and newspaper clips reporting on what President Berger said, and even worse, newspaper clips that themselves are inconsistent about what President Berger said or didn't say. The newspaper clips, when you analyze them in context, and there's another slide coming up that does that, some of them report that Mr. Berger was simply saying they never had the $50 million they needed for investment in the railroad. And some of them say that, what claimants say, that he said that they needed $50 million or else they were going to proceed with the Lucido Declaration. But again, inherently unreliable. And what can't be denied is that there is no communication from the government to FVG that there was ever a request by the government to either invest $50 million in the railroad or else the Lucido Declaration would be issued. There's no evidence to that, and claimants, witnesses, have told you that. We've submitted here a quote from Waste Management that talks about the inherent unreliability of statements made by political figures in the heat of public debate. And again, we'll get to a little bit more about that issue later. Now, on the issue of renegotiation, again, I think in relation to the question posed by Secretary Eisenstadt, I ran through a good amount of this. I, again, ask you to really focus on the fact that the reason these issues were being discussed in tandem is that claimant asked President Berger for him to conform a commission to resolve all the issues between the parties. And it's natural that if that were to happen, all the issues were going to be on the table. Again, other, I think, important signposts of evidence on this issue. The Lucido Declaration, you heard it from Mr. Marroquin again, when claimants complain about this in early May of 2006, what does the government do? Well, their chief negotiator didn't know about the Lucido Declaration, obviously couldn't have been using it as a threat. He told you that today. But moreover, at the highest levels of the government, the president himself stopped the Lucido process back in May in order to give the parties time to negotiate. Again, as I said in opening, that is the direct opposite of using the Lucido Declaration as a threat mechanism or a pressure mechanism to renegotiate their agreements. I talked already about what happened on the 24th of August and that settlement agreement. I ask you to just look at the settlement agreement and the testimony relating to that. And lastly, again, I remit you to R36 and R37, and in particular, in R37, you will see that, and that's not before you on the screen now, but in R37 you will see that, and there's testimony to this effect from Dr. Gramajo, from Mr. Fuentes, their witness, that during the negotiation meetings, Mr. Sen said it was, the issue of fixing the legal defects to FVG was a secondary priority. They didn't really care about it because they were more focused on the other issues that the parties were discussing. The statement made by the Attorney General during the private meeting, I talked about it in opening. It didn't really feature much during the hearing, but it was referred to again. And again, it's a statement made in a private meeting. It was not communicated to them. They put up a clip of the Attorney General in relation to another issue, expropriation. Again, unreliable. It's a newspaper clipping of something that he purportedly said. No evidence, we believe, as to this, which has in essence become the central point of their case now, that the government was somehow using the Lucido Declaration to force them to renegotiate their rights in the other agreements.
Mr. Orta,
Yes, sir.
one of the concerns that one might have about the whole Lucido issue was that it was never very clearly explained. Okay, people pointed to these legal difficulties, but the claimant had been through a bid process. It had rights. We were only concerned with one contract. It had rights independently of that, which were valuable. It had made an investment. None of that seems to have factored in the decision-making at all. Now, you may say, well, there's simply no discretion. There was debate between the legal experts on that. But frankly, I find it very hard to understand how, when it comes to a matter such as the interests of the state, in relation to a declared interest and a manifest interest in the state in having a functioning railroad, how those factors were irrelevant. I just find that hard to understand.
Professor Crawford, I don't think that the evidence suggests that those factors were irrelevant, and we don't have testimony from President Bourget as to exactly how he factored in the issue of the how this Lucido Declaration would affect the rest of the investment. What we do know, however, is that the President was counseled that this contract was illegal and that action had to be taken. We also know that the President asked on a number of occasions his other public officials to sit at the negotiating table and try to resolve a resolution of this issue and other issues with FEG. And we further know that, just in terms of the evidence that's before the tribunal, that when presented with a possible settlement of these issues, the response was, I have no authority from Mr. Sen. There was no counter proposal. There's no statement from Mr. Sen during the meeting on 24 August. Let's put the other issues to one side and just resolve today the Lucido issues. I mean, that's absolutely missing. In fact, what you heard from him is he didn't make any counter proposals. He viewed C-44 as a threat, and he basically walked out of the meeting. He didn't even bother to call Mr. Posner or Mr. Duggan or anyone else who he was reporting to see whether there was a way to resolve just the issue of the Lucido Declaration. And you further heard from the government witnesses at that meeting that they never said, you have to resolve all of them or we won't resolve the Lucido issue. Rather, they put before Mr. Sen and his lawyers a proposal that would have resolved, had the parties been able to reach a negotiation that day, the issues in relation to Contract 143 and 158, but what they were met with was a response that there was no authority and they didn't want to proceed with any further negotiation. I hope that's addressed your question. In relation to what the evidence shows, again, I think there's ample evidence that the government was acting in good faith at all times in these negotiations. You see it time and time again from the President's instruction to form the high-level commission, his decision to suspend the Lucido process, his instruction to his advisors to continue to negotiate with FEG to avoid the possibility of the publication of the Lucido Declaration, and to continue to negotiate with them afterwards in an effort to resolve the issues before the administrative court action was starting, or would start, I should say. On the issue of damages, what we know is that I think it's pretty undisputed here, notwithstanding the comments otherwise. The claimant was never profitable. Their investment produced only losses. On the issue of the supposed future possible leases and easements and other things, what is the hard evidence before you? You have a number of letters that were all sort of organized immediately after the Lucido Declaration was issued. We find it somewhat remarkable that all of these letters were sent in such a short time span. But be that notwithstanding, you have no contracts. Where are the contracts? Where are the documents that would support that all of these supposed deals were about to happen or would have just happened? They're simply not there. You have evidence before you that from one of the witnesses that it took them over 2 years to try to come up with a lease, and they couldn't come up with one until just before the Lucido Declaration was issued. And further, that in relation to the contracts that actually did exist pre-Lucido, that they still have them, they're still benefiting from them, and their revenues have in fact gone up since the Lucido Declaration. On the issue of what really happened, again, I think it goes to the second question that we've put before you. We know that there was a defunct railroad with notwithstanding the efforts made by FEG, however you want to characterize them, they simply were not sufficient. And what we do know is that when they're seeking $65 million from this tribunal, they're in essence not only trying to use CAFTA as their insurance for their failed investment, but they're asking you to award them a 22% annual return on this failed investment. That's calculated directly based on the number they're asking for. Again, this case is being used as their golden exit strategy. The statements from I believe the financials are very telling. Mr. Posner telling his shareholders.
Excuse me, can you just point us either now or at some point to where you're contending they were asking for a 22%?
Yes, that's a calculation made based on the $65 million that the investment they made and the $65 million that they are claiming in this case. Now, statements from Mr. Posner contemporaneous statements before the Lucido issue came up. He tells his shareholders that they're treading water, that they're cash flow negative, that they're having difficulty obtaining financing. And what we do know is that immediately upon the issuance of the Lucido Declaration, they began planning this case. We have an email on the 11th of August where Mr. Carrasco, one of their lead lawyers in this case, is saying we're working on the international legal proceeding that might be available to us. I will remind you this is the only international legal proceeding they have filed in relation to the Lucido Declaration. Just the day before, and this is quite telling, a couple days before the Lucido Declaration is published, they are signing a long-term contract with Hisur, and that is evidence of the fact that they knew they were going to continue to profit from this, even though they were going, meaning the usufruct, even though they were going to try to put this claim together. Mr. Sen showing up without negotiating authority on the day before the Lucido Declaration is published. The publishing of the paid advertisement on 28 August, the first business day after the Lucido Declaration is issued, and that's substantiated by R36. In that statement, Mr. Posner telling the world that the government of Guatemala had just begun an expropriation of RDC's investment in Guatemala. That's directly taken from the paid press release. Statements at the negotiating table on the 28th of August asking Mr. Sen to please instruct FEG to stop the media campaign in relation to the Lucido Declaration, given that there were negotiations going on. Press conferences called by FEG at which Mr. Posner traveled to Guatemala to attend. And the statements for those press conferences, you have them on the record and we've cited them here, mischaracterize the effect of the Lucido Declaration. They cite two comments by President Berger. They were clearly made after the press conference and in response to their press conference. And if you listen to it carefully, you'll see that he says so. And very shortly after that, they're hiring their damages experts. Mr. McSwain said to you he was hired in 2006. That doesn't sound like a company who's trying to salvage their investment. March of 2007, they've filed their notice of arbitration, and then June of 2007, their request for arbitration. We've talked about the issue of estoppel, and I think I've addressed this in relation to the questions posed by Secretary Eisenstadt, so I won't rehash all of the issues here, but I think it's important for you to focus on the fact that claimant knew, FVG knew at the time it executed Contract 143 that it was entering into a contract that did not comply with Guatemalan law. You heard Mr. Aguilar and Mr. Mayota, both were consistent on this point. It is improper to incorporate bidding terms into a contract and then to deviate from bidding requirements in that contract. And that is precisely what happened in Contract 143 in relation to the issue of government approval. I want to say that again because that is the direct proof that FVG knew that they were violating Guatemalan law when they entered into that contract. They cannot claim ignorance of the public contracting law here. They can't say, well, Mr. Sarceño was willing to do it, the FEGWA overseer, and therefore it's okay. They knew that it was against the law, and they did it anyway. And so they shouldn't have any reasonable expectation that Guatemala is not going to use the Lucido law to address that and other important illegalities. Now, we've talked about the issue of the public bidding. Again, they also knew a public bid, or should have known a public bid was required.
Excuse me, let me just, on that one point, even if Ferrovios knew or should have known of the requirement incorporated into the contract from 41 on the bid, if both parties in effect proceeded on the basis that it was not needed, notwithstanding that, why is it then that Ferrovios should have known that one of the two parties, namely FEGWA, was going to change from what seemed to have been, perhaps from your own statement, a consensus? Both knew, both proceeded on that basis. Why would Ferrovios have reason to think that at some later date that FEGWA was going to change its opinion?
Well, it's our contention. Why are they entering into a contract? If you look at the evidence, up until August of 2003, how were they using the rail equipment? They were using it based on these letter agreements that had been exchanged with the overseer. And again, this evidence is unrefuted. What were they paying for the use of the railway equipment up until August 2003? Nothing. They had letter agreements saying they would pay. They proposed the letter agreements. And you heard from Mr. Aguilar yesterday, they proposed the letter agreement, I think it was 17 days after the contract 41 went into effect, when they knew that at a minimum it was going to take some time to get the government approval, and that the contract would not go into effect until 30 days after that approval was obtained. That's right in Section 6 of Contract 41 and in the bidding terms. So they knew that they shouldn't be requesting the use of the equipment through the letter authorizations, but they nonetheless did so, and then they proceeded to use the equipment for almost 4 years without paying for it. So a few, and this is important, a few months, just 3 months before the end of the administration, the prior presidential administration, they enter into backdated leases with the overseer in order to make up the payments for their use of the equipment for that interim 4 years where they weren't making any payments. They make those agreements and then immediately terminate them and enter into this other agreement. Now, in light of that, in the face of that, and in the face of their knowledge that this requirement was necessary, and hence why they were operating under these letter agreements for the prior 4 years, they can't benefit from that conduct here in asserting their CAFTA claim. And the other response to your question, Secretary Eisenstadt, is that a few months, a few short months. You even heard that. You even heard Mr. Sen say it was almost immediately, and we know it was because it's unrebutted here. In March of 2004 or April 2004, which is literally three months or 4 months after, 5 months, something like that, after the amended Contract 158, they make a request from the new overseer. There's a new administration coming in, and my conjecture, it's conjecture, that the reason this contract gets signed when it did is because there was a new presidential administration coming in and they wanted to regularize their use of the equipment. Again, that's my conjecture based on the facts. Now, what happens is they make a request for use of the equipment to the new overseer, and what does he say? And this is unrebutted. He sends back a letter saying, I have to deny your request, see attached legal opinion, and the attached legal opinion talks about a few legal defects, including the lack of executive approval. So what reasonable, I don't think it was reasonable for them, I contend, to rely upon this this acceptance of this contract by the overseer in the face of what they had done in the 4 years preceding, and in the face of the fact that they immediately were told by the new administration that contract is out of bounds and against the law.
Is there any,
Excuse me. I would ask that you be as succinct as possible in the replies, because we have no time.
I understand that, and I will do my best.
last point on this, is there any relevance to the fact that a prior overseer in the year 2000, under 41, went directly to the president to try to get him to sign 41 and testified to us that it's mystifying to him as to why that wasn't done? And then under 143, it doesn't get done. I mean, there seems to be this pattern of not getting presidential approval. So is there any relevance to his testimony?
For the issues that are being decided in this case, I don't think so, because I think the question, I mean, this is not a case about whether the government declared Lucido Contract 41. The parties together terminated Contract 41 when they entered into Contract 143, and the legal opinions all say, you know, once that, I mean, that's a terminated contract that the parties have by their consent terminated. So you can't revive that one, to my understanding. And as it relates to Contract 143, as you heard, you can't submit an illegal contract to the president and ask him to approve it. You know, you had to enter into a new contract, and you had to have a new public bid and cure the legal deficiencies. So moving along, you know, we believe that the record establishes, you know, that there should not be any estoppel as has been requested by claimant for the reasons we've argued for, and the reasons that I've just asserted in terms of the conduct from the claimant. On the, and I'm going to move through, you know, some of these things. These are points that I've made to the tribunal already. You know, claimant recognizes after they're told that the contract is deficient immediately by the overseer. They knew the contract wasn't being accepted. They wrote to the Vice Minister of Communications, telling him that, asking him to formally acknowledge the contract, and talking about the fact that they were in negotiations to enter into a new contract. They knew at the time that the government wasn't accepting the contract. They've crafted a different argument here for litigation, but that's not what the evidence shows. This is document R9. I've been through the issue of the president's decision being reasonable, so I'm not going to go into that. I will point out to you, and I think this is important, the theory of the case has changed. When you look at the press release that the claimant put out, that's most close in time to the issuance of the Lucido Declaration. The alleged government motivation for the Lucido Declaration was withdrawal of the local arbitration process, appropriate the claimant's investment without payment, and the giving of the usufruct to, they say, private interests, and we assume they meant Mr. Campoyo, although they didn't name him. Same in the request for arbitration, but then when they get to the memorial for the merits, then they begin to talk about the Lucido Declaration as a threat instrument to get them to renegotiate contracts. So by that point, now with the benefit of their lawyers, they come up with this different theory. And then not until the reply in this case do we first hear about this $50 million business. So I think that is quite telling in terms of what they really think. The other thing that we'll point out very quickly is that the amount that they have claimed in this case has been remarkably consistent, and we believe it's a remarkable coincidence that in the notice of arbitration they sought $65 million, claiming 50 and 15, 50 in lost profits and 15 in lost investment, and this is before their expert was involved. And you heard him say, Mr. Thompson, he had no involvement at all in these figures, but yet the experts today come up with the same number, 65 million in essence. I do want to raise one legal point, which I think is important, and that is, this tribunal has already ruled that the issues in relation to squatters and the eviction of the squatters and the trust payments is out of this case, and that those measures cannot form the basis for any finding of liability in this case, and we just reassert that point here because there's been a lot of discussion about pre-Lucido conduct by the government here. And while we recognize that the awards allow you to look at that for context, it's certainly the doctrines, well-respected doctrines of ratione temporis and which I don't need to tell this tribunal about, don't allow you to point to or rely on government conduct pre-entry into CAFTA in order to find the government liable under CAFTA. Now let's talk about the legal claims. Okay, we, as I contended at the beginning, we believe they haven't proven any of them. And I'm going to spend the most time talking about fair and equitable treatment because I think that with respect to the other claims, while I'll discuss them very briefly, I think that there is absolutely no evidence at all for any of their claims, but in particular for these others, I think they're very easily disposed of by the tribunal. On the issue of indirect expropriation, the claimants have conceded. It's a matter of record here that Guatemala, as a legal matter, didn't interfere with any of their contracts. They have every right that they ever had under contract 143 and 158 today. They have possession of the rail equipment. They have every right they ever had under contract 402, the right-of-way contract. They have that today, and they continue to profit from it. The why, and this is a very interesting question for the tribunal, the why they haven't gone out and tried to continue to exploit their rights under that agreement, the why they're not going out and trying to collect rent from all these industrial squatters, well, Guatemala shouldn't be liable for that. They decided unilaterally to leave the country in a very public way, with a public announcement, with Mr. Posner being in the front pages of the newspaper in September of 2007. They announced it in March of 2007. And we, meaning the government of Guatemala, should not be responsible for their decision to leave the country and not exploit their usufruct rights that they, again, still have today. On the issue of interference, again, I think based on what I just said, as a legal matter, their property rights have not been interfered with. They claim that they have an inability to generate economic returns from that investment, but again, we believe that's not the case. The reason they're not generating any more economic investment from their usufruct rights is because they've decided not to pursue them. They left the country. They're not out there trying to collect rents from the squatters. You heard from them, 92% of their investment is their right to exploit the right-of-way for real estate values. But they're not going out there and doing it. That's not Guatemala's fault. Guatemala's not preventing them from doing it. We claim that they've not offered evidence on the issue of interference. They've also not offered evidence on the issue of the substantiality of the effect of the expropriatory, what they claim is the expropriatory act, here the Lucido Declaration. Their revenues have gone up post-Lucido. On the issue of discriminatory intent, I think we've already dealt with it. They simply have not proven it. On the issue of the Schufeld case, which they cited in their opening, I'll just leave you to the slide, but it was not a case like this one. In that case, which was quite a long time ago, the legislative decree on its own had the immediate effect of bringing their contract to an end. That's not this case. Their contract rights are still in their possession, and they can exploit them. They've just chosen not to. On the issue of on whether this is an unlawful expropriation, I'm only going to. I think we've been through the other elements. Certainly, we believe that upholding the Guatemalan Constitution, upholding public contracting laws, are reasons that are in the public purpose and for the public interest, and that is the evidence as to why the President made the decision he made to declare the agreement lesivo. The issue on due process, I think, is again a non-issue here. You heard Mr. Franco's testimony, and I think that speaks for itself. And on the issue of prompt and adequate compensation under CAFTA, that's not due yet. Again, we don't think there's been any expropriation here, but that claim is not right because under CAFTA, that compensation is not due. And you also saw that they do have the ability to obtain back any monies that they paid through the usufruct if the administrative court confirms the Lucido Declaration. And you also heard from their own witness, Mr. Franco, that they have the ability to file a separate action to seek damages, even if you don't believe they can seek damages in the administrative action.
Is there some point in time after a number of year delay, administrative court not ruling, that one could come to the conclusion that there's not going to be a ruling, and therefore prompt and adequate compensation should be due?
I suppose that would be possible. I don't think we're even close to there yet, because what the record evidence establishes is that the evidence, the proceedings closed back in 2010. So they've been waiting for a ruling. I believe I don't want to misspeak, but somewhere around a year. It's not entirely uncommon for ICSID tribunals to take a year to issue rulings. I don't think it can be said that in Guatemala, the fact that there isn't a ruling yet, especially in the face of requests by the government for a ruling to be issued, that should be given any weight here. On the issue of fair and equitable treatment, I want to spend a little bit of time, not much, but on the standard, because I want to highlight again, as I did in opening, that this is the first tribunal who's going to make a determination about what the fair and equitable treatment standard means under CAFTA. Again, both parties agree customary international law, but they disagree on what that means. And I think that is a very important issue that this tribunal will have to struggle with. We have said that the standard can't be what the claimant has articulated. It can't be whatever you find in any arbitral award, because those arbitral awards, in order for them to be relevant for this tribunal, you need to first reach the conclusion that those arbitral awards were making decisions on what customary, or applying customary international minimum standard of treatment under customary international law, and claimant has cited a number of awards that are not doing that. And so we believe the standards they've articulated in that regard should not be utilized here. The standard under 10.5, and I'll read from, it's not up on the screen, but Annex 10B says that the CAFTA parties, in asking tribunals to apply customary international law, they say it has to be something that results from a general and consistent practice of states that they follow from a sense of legal obligation. That's not arbitral awards citing autonomous standards. That has to be established by the claimant, and we believe that the Glamis Gold Award, UPS Award, and others that we've provided to the tribunal are ones that articulate the right standards. Again, you should not be looking at autonomous standards to determine what the minimum standard of treatment is for fair and equitable treatment in this treaty. On the issue of the minimum standard of treatment, we submit to you, the Cargill Award. I mean, these are in our briefs. This is the standard as to which Guatemala's conduct should be applied. We cite to you here RL 175, paragraph 296. The question is whether the conduct at issue here is grossly unfair, unjust or idiosyncratic, arbitrary beyond a merely inconsistent or questionable application of administrative or legal policy. I want to pause there because I think that's very relevant for what you're being asked to determine here, the standard that's articulated here in Cargill. And it has to be conduct that is so unexpected as to be a shocking repudiation of a policy. The application of an existing law made at the time that they invested is simply does not meet that standard. We also cite you to S.D. Myers, which we think is very relevant for your decision making. Tribunals should not be second-guessing government decision making, and the standard really is a high one when you're being asked to do that. And here you're being asked to second-guess a decision that's made by the highest official in Guatemala, the president. So this is the standard, and we believe that as applied to that standard, we've proven we haven't violated it. The reasoned government opinions informed the president's decision. He took the actions for important reasons, protection of the public interest. He would incur in personal liability, or at least he was told he would, if he didn't take it, and that does not establish a fair and equitable treatment violation under CAFTA. Far, far from it. On the issues, on the standards that Claimant has articulated, as we said in opening, we believe that we meet the standards that should be applied, and those are the ones that I just talked about. But even if you judge Guatemala's conduct based on the standards that Claimant has asked you to judge them against, we believe that the evidence shows that we've not violated any of them. In the interest of time, I'm not going to go through all of the evidence here. I submitted to you. Everything that we have cited here is backed up by quotes or cites to the declaration. I'm sorry, to the evidence in the case. Now, again, no violation of due process, no arbitrary conduct by the government in relation to the issuance of the Lucido Declaration. No frustration of their legitimate expectations. Again, we claim they don't have a legitimate expectation not to have the contract that they knew was illegal challenged by the government. On the issue of transparency, again, the Lucido law was on the books, and they signed up for it when they invested in Guatemala. Nobody made any assurances to them that this Lucido law would not be applied as to their investment. No one. Full protection and security. I think, again, I'm not going to spend much time here because the real issue is, did the government act with due diligence? Did they take reasonable measures? And we believe that the evidence shows that they took reasonable measures. The best that Claimant has been able to muster is point to a few instances where they suggest Guatemala didn't act as quickly as they wanted. That's not a violation of full protection and security under CAFTA. Again, it doesn't even come close in our estimation. On the issue of squatters, and I want to pause here again very briefly just to underscore the point we made both during the hearing and in opening. There is no evidence, we think, reliable, credible evidence about the industrial squatters and when they got there and whether they were there pre or post Lucido. And perhaps an even more important point, no evidence that those industrial squatters didn't decide to go and invade the right-of-way when Claimant made the very public announcement that they were abandoning their investment and leaving the country. All of the pictures that were remitted to you were from 2009 to 2011, and that is more than 2 years after Claimant publicly told all of Guatemala that they were packing up their bags and heading back to Pittsburgh. So no violation of full protection and security. On the issue of national treatment, again, I think this is a non-event, an easy claim to dispose of. It's a different railway. It's not the same kind of business. It has been no showing that Mr. Campoyo is in like circumstances, or that he received any more favorable treatment as compared to them. With the few minutes I have left, I want to talk very briefly about damages. On the issue of damages, again, I think that the evidence before this tribunal is quite stark. And again, I want to remind you the context in which you're being asked to award claimant $65 million. They had made an investment. They had only restored one phase. They had only been able to procure very limited right-of-way contracts for the real estate, and it's unrebutted that they had only losses from day one until the day they left the country. Only losses. Now, notwithstanding that they're asking you for $65 million, and again, we point out the remarkable coincidence between the numbers that they've sought from day one and that their experts have validated for them. Their experts have remarkably reached the same number that they were asking for before they hired their experts. The setting at the time of the Lucido Declaration was a business that produced only losses, a huge problem in relation to the building out of Phase 2 because they couldn't get funding for it, and the evidence is undisputed that at a minimum they would need at least $100 million to build Phase 2, and there are estimates that are much higher. I remit you to document 322, where Mr. Duggan makes estimates at right around $100 million. And, you know, the question is, would a willing buyer really be willing to pay a willing seller anything for that? Anything. When the only way they stayed out of bankruptcy was asking their shareholders for capital contributions each and every year. Warren Buffett's name was invoked here. What would Warren Buffett pay for this investment on the day of the Lucido Declaration? I think the answer is nothing. There's been some suggestion in terms of the damages award that that somehow the tribunal should award a different set of damages in order to somehow punish Guatemala for their conduct. I realize the chairman made a statement on the record that, of course, under CAFTA that's not allowed. But our point is that it looks like the claimants' experts are seeking exactly that, based on their testimony in this case. On the issue of the future profits claimed, again, we believe that they're highly speculative, and that there's no real evidence of it. Again, what you have before you here in C-27 is their actual record of operations. They lost money every single year. In relation to, again, what you're being asked to believe would have happened, they're asking you to believe that their real estate revenues would have gone up because they would have dramatically changed and altered what happened in the first 8 years that they were in business. You've been given no proof or evidence to really reach that conclusion. Again, where are the contracts? Where's the hard evidence that any of this was anything other than something that they hoped for, or something that was more of a pie in the sky projection? There is none. On the issue of the real estate revenues, the railroad revenues, again, same thing. And especially when you consider that they had, as of the date of the Lucido resolution, they had no viable sources for funding for the rail project. Same thing, just look at their own statements. We remit them to you here. Look at their contemporaneous statements where they tell you that there was no demand for their right-of-way, no demand for their rail operations. On the issue of what is the fair market value of their investment, again, we don't believe that they have proven that it's anything other than a negative value. They cite to a lot of these industrial squatters. I've made the point about them. They sent you pictures about them. You might have wondered why I maintain my objection as to the authenticity of some of them. Well, the fact is that, and I don't remember which slide it's in here, but 25% of those pictures, 9 out of the 36 of them, were taken apparently by somebody else, because Mr. Sen's testimony is he took them within a 2-month time frame. But again, 25% of them were not, by their, if you just believe the date of the picture, were not taken on those dates. So we don't know who took them. We don't know where they're from. And that is why, if you were wondering, I maintained my objection as to the authenticity. So in closing, we maintain that the fair market value of the investment, as I think correctly projected by Dr. Spiller, is that at the time of the Lucido Declaration, they had their business had a negative $2.7 million value, and as a result, when judging what would a willing buyer pay a willing seller for that investment, for that asset, at that period of time, we believe the answer is 0, and claimants have failed to prove otherwise. With that, I will, in about 10 seconds here, just tell you about our prayer for relief. Again, we believe that we've proven that they've not made out a case for any of the CAFTA violations that they've asserted in this case. And we therefore believe that Guatemala should be found to have not violated CAFTA, and its attorney's fees and costs and interest should be awarded. I think especially when you judge the quality of the evidence before you. If you award any damages, we say that those damages should first be conditioned on their renouncing all of their rights under the use of contracts. This went directly to the question posed by Professor Crawford to Mr. Foster at the end of his presentation. And, well, that might be the end of my presentation, but unexpectedly. We believe that the number here, if you were ever to get the damages, should be 0, and we would remit you to the Bywater golf case, where there was a similar scenario in relation to, in that case, the tribunal found liability, but found that the fair market value of the investment at the time of the alleged violation was negative, and therefore awarded 0. Again, we believe there's been no establishment that there's been any violation of CAFTA, but if you get the damages, that's what we believe the right result is. And I want to thank you for your time this morning.
Thank you, Mr. Horta. We will have a break now, and we will reconvene at 2:15. And so have a good time at lunch.
Thank you, Mr. Chairman.